Well, you train students, about 500 students, 474 or so students. Then only 91 pass. A lot referred. I mean, how can it happen? I mean, something is fundamentally wrong. Something definitely. You don't train students to fail. You train students to pass. And if this huge number of students have failed, then there must be some soul searching. No teacher will embark on a mission to train students to fail. No teacher. It's not part of the core. I mean, it's not part of the values of teaching. You impact knowledge to train useful and responsible citizens of the country. And so when you have this abysmal performance, then you need, because there are interim assessment examinations within every institution. There are quizzes, there are tests, there are assignments, so that you get to track the performance of your students. And so if at the end of all these things, I mean, if the assignments were giving you scores that clearly indicated that your students were making progress, and then in the final examination they failed, then there is something fundamentally wrong. I think there should be an investigation. You are discriminating based on your own personal idiosyncrasies. I mean, if somebody passes the exam, you say you should go for interview, and you ask some questions about Al-Qaeda and then existence in Maghreb. I mean, how does it relate to law?
If we open the gate, are we not going to allow?
There's no opening of gates. We need more lawyers. There's no opening of gates. Open the floodgates. If anybody qualifies to be a lawyer, have you seen them restricting entrance into a medical school? If anybody wants to be a lawyer, he should be a lawyer.
The General Council last meeting,
I said they are wrong in restricting people.
They received comments from the bench and the bar that the standard is falling.
Oh, you shouldn't have said this to me. If a person goes through the law school and is called to the bar, then the bench says that, the judges say that the students, the lawyers who are appearing before them appear not to be up to the scratch. Who should you blame? The students? The General Council. Because now you have gone through the training, you have selected them, they've written exam, you have trained them, you have called them to the bar, you certify that they can practice as lawyers, they go to court, and the bench is saying that these people that you have produced, they're not up to the scratch. And you are blaming the students. You blame the institution that has trained them. You don't blame the students. Yes. Because any institution will take pride in the students that it has produced. And these students go to court, and the court says, hey, what kind of students are you producing? You don't blame the students. How did you pass him? How did he perform that you passed him? How did you assess him to say that he's qualified to be admitted to the bar? So me, I don't blame the students, I blame the law school.
As the professor has said, okay, the drafters of the act made it very clear that you can use alternative, institutions of instruction. So, as a starting point, if the Ghana School of Law is, lacks capacity to be able to absorb all of these, they can use alternative schools of instruction. And I was thinking that in the article that I wrote, I actually pointed out that you could actually start with the law schools that award the LLBs, okay, the faculties that award the LLBs. Let all the practical courses that you are talking about be taught in those as clinical programs. And then
those law schools, law faculties, we have almost about a dozen now, right, in the country?
Yes.
Okay.
Yes. So the proposal is that they can serve as the alternative, schools of instruction in addition to the Ghana School of Law, and let them teach clinical courses just like the law school is, teaching the practical courses, and then let the students write a common exam at the end of the day, okay, and that will solve the problem. Once and for all.
You don't appreciate their concerns of the capacity of these other schools and the quality. A major concern is the quality.
Samson, in 2015, I addressed the Ghana Bar Association National Conference in Kumasi.
Yes.
And I took the liberty, to address this issue. And I said, and I'm going to repeat that.
Including quality of judgments by judges.
Yes, yes. You see, when a person has been taught by Professor Kumado, okay, one of the leading authorities on constitutional law in this country, and he's roaming the streets of this country, seeking to enter the law school, I think it's unpardonable for you to say that that student is not qualified, to write the professional legal exam. For me, it is something that is unacceptable, okay, because the quality of training at the Faculty of Law, where I taught, okay, the standard is so high, right? But there are Faculty of Law, University of Ghana students who have been seeking to enter the law school for 3 years consecutively, and they have not been able to do it. So how do you explain that? So you don't just take one example of a law school that is not very well organized, whose curriculum you have, the teaching, the quality of teaching you have problems with, and you say that is, you take an outlier case and say that is, the basis for you to say then that the quality of training in all law schools is so bad that you cannot allow them to.
Giving you an example of where they had to lower the score that they were looking for. They lowered it, and they still couldn't get the numbers.
That is.
Even when they had opened up, they were ready to take up to 600. They lowered the score, and they didn't get the numbers.
Something. The problem is the system itself that they are running. If you have a situation where the students don't know, how the questions are, are set, or where they are going to be set from, whether it is in the area of constitutional law, the law of contract, equity and succession, and so on and so forth. And then you set 5 questions out of 9 subject areas. I'm just astounded by what is happening, because it is not. I could fail that exam. Seriously, and it is not because I'm not intelligent enough to write the exam, but it is the manner in which they are running the system. I'll give you the example of Kenya. In Kenya, the law actually specifies the subject areas, and then the examinable, subject areas for the students. So you know ahead of time what you are supposed to do in preparation for the exam. In our case, we don't know. So the independent examination body says these questions, surprises the students. Most of them go in and then they fail. And you say that as a result of the fact that they didn't do well, you are lowering the grade. It's because of your own lack of diligence. It's because of your inability, to do a good job. That is why the students are failing.
So in a minute, tell us, is it practically possible what is being proposed as the alternative within this immediate term?
I think so. I think if they, for instance, decided that the law faculties should teach those practical courses, and then the students should take a national exam, all the law faculties should be ready to ready
faculties that are already stressed. Some of them are getting closed down because they don't have the requisite number of teachers.
So you close the ones that you close down, and then those that you think they have, the quality standards to be able to do this, they should go ahead and do it.
Interesting. Yes, Wabi.
Taking off from where you left off.
Yes.
I sincerely don't think the medium to long-term solution can be immediately implemented. I'm a member of the subsidiary legislation committee. Actually, I'm the ranking member on that committee, and I feel the emotions and the tensions. I've listened to the students and everybody. Indeed, the best we can say for the General Legal Council is that they've been tardy. They've waited and allowed this to overcome them, and therefore they are caught flat-footed. Because you're talking about standards, and we all agree that standards ought under no circumstances be compromised.
Right.
And yet, if you allowed successive universities to be accredited to offer LLBs,
they are not in charge of accreditation.
That is the question.
That's not the General Legal Council's business.
The question. Ought there to have been some sort of collaboration between the General Legal Council and the Accreditation Board? That's one of the questions why I insist that
if someone applies, if someone applies for accreditation and they meet the qualification criteria provided by law, the National Accreditation Board cannot say no. And the General Legal Council cannot dictate to them that if they come, expect this extra, things. Otherwise, they'll go to court and throw them away.
But it is one of the subtle reasons that the GSE is proffering for having an exam, that they can't vouch for the quality of the LLBs they are being asked to admit. Apart from the other 2 reasons they are giving, that they are short of faculty, quality faculty, and that they are short of infrastructure. But you cannot say numbers compromise quality necessarily. You can't say that. That argument is not tenable. Neither can you say that a paucity of faculty and infrastructure should restrict people's rights to an education if they can afford to meet the qualification criteria. The nub of the matter is whether or not the qualification criteria as it stands enables all the people who are supposed to have qualified to enter.
So now the about a dozen faculties are producing in excess of 1,000 LLB students, and only 450, or as they are trying, 500 plus are being admitted. Should this still remain the solution?
No, I think that the media likes to call it a saga. I think this gives us an opportunity, and we've told the GLC ad nauseum. I would have loved to see them even now convene a national stakeholders conference on this matter in order to restructure the entire phase of legal education. At 32, it's probably older than me. I was born in 64. At 32 is 60. It's too old. It hasn't seen, but it's a very resilient piece of legislation, except that it still needs to be modernized, given the numbers, given the new needs, given other considerations. They must move swiftly. But I'm saying that in the interim, even moving to changing the architecture is a medium-term situation. And we are looking at 12, 18, 24 months probably. Within that period, I expect that an LI must be put in place to regulate the process for now.
In the meantime, you are saying that this LI must...
No, in the meantime, to the extent that, again, there's a certain emotiveness about the current LI. I think we must go back and interrogate the Supreme Court decision. And happily for all of us, June or July 2017, I think the High Court Justice Anthony Yeboah did a superb analysis of the decision. And I love the way he put it. He said that notwithstanding the unconstitutionality of the actions as declared by the Supreme Court, the Supreme Court also put in a condition. So it's a conditional unconstitutionality. So the condition is that, yes, that's the word he used, conditional unconstitutionality. And therefore, there's a window of opportunity for GLC to resolve the issues by putting in place the measures that ought to make their actions. The question then arises, who are to be impacted by the current LI? The backlog from 2015 to date, or the prospective students? If it's the prospective students, then the GLC is faced with the prospect of a floodgate being open for 3,000 people to swam it, and they are afraid of that. They are genuinely afraid of that. So what is the Supreme Court's ruling, and what is the interpretation? As far as
we are concerned, this LI will pass. Then the problems will be solved. The other problems will be solved later.
It will pass because of the nature of subsidiary legislation. Because the LI as it stands doesn't appear to contravene Act 32. Section 13 and 14 of Act 32.
Thank you. Now.
But that's because
I've heard you, Muntaka, suggest that this should not be allowed, and you are beginning to advocate for the students, and they are happy about you. You have joined those who say there's a shortfall of lawyers. We have not more than 3,000, just a little above 3,000 lawyers or so. It's actually not 3,000. We have like 2,000. 2,000. We have like 2,700 lawyers in the whole of the country, and out of the total number, 2,000 plus are here in Accra practicing here. And you say, because of that, the way to do it is what Professor Kokwasari and others are suggesting.
Yes.
So the LI should not pass.
In fact, I am impatiently waiting for the subsidiary legislation to finish. And I'm praying, I've been working very hard to be able to get to third of members of parliament to throw this thing away. Because look, we will be doing grave injustice to our own citizens who we are representing. If you permit me, let me take just 1 minute to read the statement of Kwame Nkrumah when he was opening the Ghana Law School on January 4th, 1962. This law school, whose building I'm formally opening today, was founded less than 2 years after Ghana became independent to prepare students to become lawyers. The objective of the school is to give both full and part-time tuition in law so that those who had wished to become lawyers but who could not in the past afford the large sums required to study at the Inns of Court in London can now qualify. The lawyers needed in a developing state are, in the first place, those trained to assist the ordinary man and woman in his everyday legal problem, and particularly in the new problems likely to arise through industrialization. For example, lawyers are required by the trade union movement to assist in making effective agreement with employers and seeking to its
that the individual trade union is obtaining what is legally due to him if he is injured at work or is illegally dismissed. In the same way, lawyers are required throughout the country so that in some towns and villages, inexpensive but very good advice can be had by the ordinary man.
That's so, okay. I mean, the Attorney General says that even the state attorneys that are required,
yes,
they need in excess of 600. But at the moment, they have about half that number.
I had not finished, but it just gives you the background.
Yes. No, it's not post-salary.
Looking at what the shortfalls that we have, and the method they are using, where's your O-level results? You probably don't even know why it is. Do you know why? By virtue of creating WAEC for you to write, I don't know whether you wrote SS or O-level. For those who wrote O-level, you write O-level to gain new entry into A-level for you to be certificate. It has become useless because all I needed was to take me to the next level, which I've managed to move to the next level. Believe me, the LLB that they are having.
When I entered the university, there had been a problem. The university needed to conduct entrance exams. We had to sit them before we enter.
We all criticize it, and where is it now? Are you still writing? Are they still writing? The same SSB, are they still writing? Because we said that is unfair treatment. Because the person has already gotten what it must take him or her to cross to the next level.
The situation dictated.
No, it's not the stake. Let me show you. Look, when this faculty, when the school was established, you know that it was attached to University of Ghana Law School. It was supposed to be one body. Then for whatever reason, along the line, we decided to separate it.
Okay.
Let me tell you this and give you a practical example.
Yes.
That requires even human life. That requires even human life. The Medical and Dental Council certify every doctor that passes in this country, but they don't set up a school for you when you finish Legon or when you finish KNUST or UDS or Cape Coast for you to now come for them to do the training, the practical training for you. You do it with KNUST, but you pass their exams. Nurses and Midwifery Council, they don't set up another school for you when you have finished as a midwife or as a nurse to come for them to retrain you for the practical. It's the same school, but they make sure that whatever facilities...
Why don't you compare it to the doctors rather?
No, that's what I'm saying, the doctors. I've mentioned the doctors. I said that the Medical and Dental Council doesn't run a school for the practicals. The KNUST Medical School, the UDS Medical School, the Cape Coast Medical School, they are those who are running the practicals together with the affiliated hospitals. So that when you finish, then the Medical and Dental Council will now assess you and you write their exams and they say you are now a doctor. We are saying that go and do that. Stop this silo mentality. You are using it, believe me, look, and I'll say it here, and I want them to challenge
you. You are getting how many signatures?
No, I need 2/3 of members of parliament to throw it out. And I'm very optimistic.
It's a very emotional matter.
Like I said, Pharmacy Council, Pharmacy Council, they are dealing with human life.
Thank you.
No, some of their training, let me just say this, some of their training require corpses, dead bodies. So they need to have a mortuary.
Right.
They are doing it. Medical and Dental Council is not the one doing it.
Okay,
why should the General Legal Council wants to be doing that clinical
thing? Thank you. The best street pocket lawyer in town. You want to make something brief? Yes, very brief.
Yes, I'm going to disappoint you.
Okay.
Look, I vote for Professor Kweku Asari's line of thinking. That's where I stand. I haven't interrogated the thing thoroughly, but instinctively, sentimentally, that's where I drift to.
Okay.
I wonder what the executive itself thinks about all this.
They have petitioned the president.
Yes, I wonder.
In other words, you agree with Muntaka?
Yes, okay. I do. Yeah. Well, and I pray Parliament does what he's saying. Yeah. Okay. That's what I have to say.
Okay.
Yeah.
Well, whilst the parliamentarians are likely, if they are minded to do so, and the president, if he's minded to intervene, the General Legal Council, all they are saying is that, well, it's money. It's cost.
In the interim,
you should take care of it.
For now. You know what? Spin. Put all the names in the list and spin. You are taking 600. Let them come and pick. You are not writing any exams. Just come. Because we have 3,000 of you. In the meantime, what do? We put all the names. Okay. Yes, no. We put 600 yes.
But again, you must note that from what they say, if you shut down this LI this year, they will not have. They will not admit the advantage for this year.
Is that a hint of a black